This is the second webinar with the League of Oregon Cities and today with the Association of Oregon Counties on the agency's proposed Goal 5 rules for cultural areas. I serve as the agency's deputy director and also at the Director Bateman's delegation, our agency tribal liaison. And with me here is Commissioner Leanne Thompson, both Clatsop County Commissioner and Land Conservation Development Commissioner. Commissioner, would you like to say hello?
I'd just like to welcome everyone here and appreciate that we're working together. The goal is noble. We want to make sure that our intentions carry out our goal in a way that is both efficient and effective, easy to administer, and really joins us in one big cultural heritage as Oregonians. Thank you, everyone, for your participation.
Commissioner, thank you. Thanks for being our liaison as well. And I want to thank Nolan and maybe Alexandra in absentia, but Nolan, would you like to come on and say hello? Thank you for co-hosting these, helping us get the word out.
Thank you. Nolan Plesha, lobbyist with the League of Oregon Cities. I've been stepping into this portfolio space as Ariel Nelson, who currently or previously worked on this issue area, is now with the city of Hillsborough. We do have Alexandra Ring from OHCS, who is now on board. And she and I are working together as we transition this into her portfolio area. Just want to say thank you all for continuing to host us in these webinars, to answer the questions that our members have provided for you and getting back to them. We really appreciate that coordination throughout this process, and thank you again for putting this on today.
Nolan, thank you. Thank you. And the League of Oregon Cities, we're very, very grateful. And I will give credit to Ariel during our early days of the rulemaking advisory committees. And as she said, how do we help get the word out early? So thank you both for taking that up, you and Alexandra in absentia. Brandon, would you like to say hello from Association of Oregon Counties?
Sure. Good afternoon, everyone. Brandon Persinger with the Association of Oregon Counties. I do natural resources and land use policy. Just want to echo Nolan. Thank you for letting us participate here. Thank you for the webinar series and also for all of the work that DLCD staff and members of the RAC have done going back, I believe, all the way to 2023. So thank you for letting us participate and look forward to the conversation this afternoon.
Thank you, Brandon. Really grateful. We know that Oregon's comprehensive planning system is nothing without a partnership between the state and local governments. So thank you. So I want to just, you folks have mentioned already, but appreciate the role of tribal representatives in the work group and also local government members in the Rulemaking Advisory Committee. We want to recognize that Native people have cared for and stewarded the lands we now call Oregon since time immemorial. And for those that like to count, I think the most recent inventories or sort of ancestral discoveries are 18,000 years of stewardship of this space we now call home. So it does put our 50 years in context, doesn't it? So we're all learning from each other and learning together and trying to, as Director Bateman has said, stop harm and do better together. State agencies in Oregon, I'll go to the next slide. State agencies in Oregon have a requirement for government-to-government relationships with Oregon's, the federally recognized tribes in Oregon. And DLCD takes that seriously. I've been serving as tribal liaison for just about 5 years now, but I do wish that I could have another career of another 50 years to just keep learning because it's immense. And I invite everybody into the learning cohort with us, and together we started this process with a survey of local governments in 2021. And many local governments responded and said they do have some programs, that many also responded and said they didn't and they would like more assistance and support. So with rulemaking, it's really important that I emphasize, it's very true that there's a program around rulemaking. Even if nothing happens with rulemaking, we'll be establishing a program of support for local governments and relationships with federally recognized tribes, in addition to in close partnership with the Legislative Commission on Indian Services. If Amanda is able to come on, and then I can do some other tasks, I'll put some of these links in the chat. But regardless, we'll put some of this key information out on the Gov Delivery email list that I hope everyone is on for this project. Maybe Elliot or Casaria, if you could put in the chat the link to sign up for Gov Delivery email notices, I'd be grateful. Let's see. I wanted to. Oh, Amanda's here.
Just so you know, I am on now. Sorry about that.
No, it's all right. This is good news. That's good news. I wanted to just point out briefly something that was pointed out by a tribal representative in the rulemaking advisory committee process, that that at the time of comprehensive planning in Oregon in the 70s and 80s, 5 of what are now the 9 federally recognized tribes in Oregon had been terminated. And I know that's a horrible term, and it is horrible, by the 1954 Western Lands. I'll have to put that in. I've just blanked on the name of the Western Lands Act, 1954. I'll put it in the chat. I think it's the Western Lands Termination Act of 1954, but let me put that in there. Actually 60 tribes in Oregon were terminated at that time. If you look up that law, and there were reasons for it, good intent at the time, but what that meant, there was also bad effects as well. And that when we went to form our land use plans, our comprehensive plans in the 70s and 80s, there wasn't a tribal entity with whom to coordinate under Goal 2, even if it had mentioned tribes. So this is a bit restorative work. Burns Paiute achieved recognition after that act, and the treaty tribes of the Columbia River were not affected. But the other 5 tribes who are now recognized in Oregon today did fight back and achieved national recognition and sovereign nation status. So we respect that status. They are sovereign, we are state, and that is all defined in the U.S. Constitution. Local governments and tribe relationships are vary by local government. And so that's some of what we hope to engender here more, is closer relationships between local governments and tribal representatives in their area. I'd be remiss if I didn't mention that capacity is constrained everywhere. We know that local governments are extremely capacity constrained, and tribes are too. So when we talk about the notice provisions in these rules, the tribes who've been participating, we have affirmation from 8 of the 9 tribes that they do want the increased notice. Even if they don't respond, they just want to know. So that's part of this, is just full and perfect knowledge. We will never achieve full and perfect knowledge, but in pursuit of information sharing, so that tribes are more easily able to participate at the local government level. Let's see. I think that is really all I needed to say by way of background context. Our rule, the proposed rule treats, and Amanda will go into it, treats archaeological resources that are already protected under statute in a certain way, and then also landscape areas, which is new for Oregon and hadn't yet been defined under Goal 5. So again, thank you to everyone for joining. If you haven't had a chance to put your name and your affiliation in the chat, please do. It's the only way we'll know if you're here today, because we didn't, I guess we do have registrants. We do, never mind. But please feel free to put your who you are in the chat. And then if you have any questions, go ahead and put them in the chat too. After Amanda's relatively short presentation, we should still have about the balance of a half an hour for those questions. And then, like we did from the July webinar, we'll work to put out responses to any further questions that we're not able to get to. On our website, you can find the previous webinar responses, and also some other frequently asked questions that Amanda and our team have developed. And essentially also today, Gordon Howard is our community services manager. He is not able to be here today, just as something personal came up. But he says that we'll do okay, so we'll try our best. And also, I believe Director Bateman is also listening, and would extend her support as well for everyone coming together to learn more about these rules. We are in the comment period, and we will be hitting that shortly. Please, Amanda, take it away. DLCD's natural resource specialist.
All right. Good afternoon, and sorry for my tardy attendance here.
Okay.
As Kirsten said, I'm going to go quickly through the rule. Hopefully, folks on this webinar have had a chance to look it over, and your review of the rule will inform your questions. But I'll do my best to capture the important elements of it. And I think we're going to go with asking questions. You must have gone over this, asking questions in the chat, and then we'll get to them at the end.
Yep.
So statewide land use goal 5 is has a lot of different resource categories in it. I think it's 13 total. And one of those resource categories is cultural areas. For a while, we moved along without having a rule for goal 5 early on in the statewide land use program. And then Division 16 was adopted to describe what we call the goal 5 process for identifying and protecting significant resource sites within the different categories of goal 5. And then in 1996, a new set of rules, Division 23, was adopted to give with specific rules for each resource category, except for cultural areas. So we are remedying that problem with this rule, which will be added to Division 23, which, as I said, is our current set of rules for administering Goal 5.
Amanda, you might just speak consistently a little bit louder.
Okay.
Thank you.
So next slide, please. So what I referred to the Goal 5 process, we call that the standard Goal 5 process for identifying significant resource sites, exploring what the conflicts might be for other development that's allowed in the areas of a significant resource site, resolving those through something called ESEE analysis, an analysis of the economic, social, environmental, and energy consequences of allowing, limiting, or prohibiting a use that would conflict with a significant resource site, and then ultimately having a local government adopt code to protect, I'm putting that in air quotes there, resource sites consistent with that analysis. And when I use the word protect under Goal 5, it doesn't necessarily mean completely conserve. It means to have a balanced approach to protecting what can be of the site, and also respecting the other uses that are allowed in the zone, and private property uses of the area where there's a resource site. So this new rule will be in Division 23. We'll be given the number 210. And that's the new rule that's we are putting into the Division 23. And then this bullet here about the OAR 660-23-0250, that's the applicability rule that is in Division 23 right now. And we have to have a little bit of an amendment to that, because that's where it says that Division 23 applies to all resource categories except cultural areas. We'll be changing that. So now once this rule is adopted, the Division 23 will apply to cultural areas as well. And next slide, please. So when we initiated this rulemaking, we brought it to Land Conservation Development Commission, and with bringing up the request to develop this rule, we recognized that we had to do it within, with respect for other very important issues that are going on in the state right now. So Kirsten already mentioned that this rule will support existing laws for archaeology in the state and permit requirements that are described in rule. Both of those statutes and rules are administered through Oregon State Parks. And of course, promote respectful treatment of human remains and these archaeological artifacts. And actually, I think I'm jumping the gun onto the next slide. So no, but let's stick, because I want to make sure that I got to this one. So within the land use program, whatever we are seeking to do to protect cultural areas needs to be done with recognition of the timelines, the permitting timelines for land use authorizations within Oregon law, and also to not be in conflict with the governor's housing production objectives, which we are all working to support. So then supporting existing laws on archaeology, respectful treatment of human remains, and so I'm on the next slide now. And then apply appropriate confidentiality measures. And that's important because one of the reasons why it has taken a long time to get to writing this rule, well, one of the reasons why it was delayed in the first place was because of Goal 5's emphasis on inventories and the difficulty of trying to figure out how to manage development around a site where this public disclosure of information about that site could lead to looting is something that has been a concern all along. And so this rule recognizes that local governments, the state, everybody involved in dealing with archaeology sites will have to do that in a way that, to the best of our ability, maintains confidentiality and only shares information as needed in order to try to protect that site. And we have available data on archaeological sites now. Some of it is kept in a database that's administered by the State Historic Preservation Office, and other data on archaeology sites is held by the tribes around the state. And so we want to make use of that information where we can in order to avoid impacts to these important sites. So next slide, please. And so I'll go into the architecture of the rule. Of course, we have definitions. We have a section that describes how this rule relates to other rules within Division 23. As you can imagine, there's some overlap, particularly historic resources and archaeological resources and cultural resources. There can be some overlap there. Cultural resources can include natural areas, and we already have rules about some natural areas. We have cultural areas could include important vistas, and we have a rule about scenic views and sites. So that section just really talks about how those rules will work in conjunction with each other. And then because the Goal 5 process starts with an inventory, the next sections of the rule, Section 3 talks about inventory of archaeological sites. Section 4 talks about an inventory of landscape areas. And I'm not going to go into much detail here because I think I'll catch that a little bit later. But essentially, the inventory of archaeological sites, we are relying as we can on SHPO's inventory of archaeological sites, but information is still augmented by information that the tribes can provide. And then for landscape areas, since there is no other inventory in the state for landscape areas of cultural importance or cultural significance, then these inventories will need to live in individual local comprehensive plans. So then the rule goes on to the protection measures, and Section 5 talks about protection for archaeological sites, Section 6 for landscape areas. And then the section 7, these landscapes of interests, this rule tries to increase communication between particularly tribes and local governments, but other culturally identified groups could also participate in bringing information to local governments when they're doing both short-term and long-term planning. But the landscapes of interest, essentially that section talks about providing notice to tribes, providing information at the time of both at when certain permits are issued, and then also during time of UGB expansion, in order to promote dialogue and then lead to some hopefully avoidance of impacts, but less than a regulatory measure, because at that point we don't have landscape areas identified on a in comprehensive plans. So we have to deal with them a little differently before they get put onto they get adopted as a resource site in a comprehensive plan. Section 8 of the rule, that is where it talks about an optional option for local governments to come up with a strategy different than what's described in the rule for protecting these cultural areas that are important to tribes, and that would occur through government-to-government agreements, and it describes how that could occur, and then those agreements could take the place of the parts of the rule that apply directly. And I'll say now that that's a part of the rule that probably needs a little bit more attention. If it doesn't go there, it'll go someplace else, because we recognize, thanks to a lot of input from the city of Portland, that the rule should also allow for optional, for a local government to optionally have additional requirements with regard to archaeological sites in particular that are not from an indigenous origin. Because what we have here, this section 8 really now just talks to tribes. So we need to do something that addresses the ability of local governments to be able to have additional requirements for archaeological sites that are not indigenous in Oregon. And then the last section of the rule, applicability, just got to have that in the rule. So that's where it's there. And next slide, please. So I've talked about the standard goal 5 process, and the way Division 23 works is that a rule for a specific resource category can either point directly back to the set of rules that describe the standard goal 5 process and how to identify a site, figure out what the protection should be, and adopt those protections, or the rule can prescribe a particular inventory, and the rule can also prescribe protection measures. So in this rule that we are looking at now, for archaeological sites, we point to a state inventory of archaeological sites. For landscape areas, we are going to need to rely on development over time of local inventory of significant cultural landscape areas. And then this rule for archaeological sites prescribes a protection program that is different than the standard goal 5 process. And then for landscape areas, it relies on the standard goal 5 process with a couple tweaks that are described in the rule. And next slide, please. So this is where I'm trying to quickly provide information on really what's important here for what local governments, what will be, how local governments will be directed to apply the rule. So for archaeological sites, the rule sets out a requirement that for all permit applications, information is included on existing state statutes and permit requirements for archaeological sites. And then, and that those are kind of applications where it's more of an over-the-counter kind of permitting or review process. There's no public process or no longer timeline involved in reviewing the application. So for that set of applications, the information's on the application itself. So then when we have land use applications that would result in ground disturbance and are reviewed through a public process, then the rule explains that local governments will send information about these applications to the tribes. And I should say that when I speak of tribes here, I'm talking about federally recognized tribes, and not necessarily all the tribes that have an interest in the city or county will receive notice that the application was received by the city or county, and then that the idea there is that the tribes would have an additional about 25 or so days. If they were aware of an important site in the area, they could let the city or county know. The city or county would let the applicant know, and then conversation could happen a little bit earlier than if we waited till the application was deemed complete and the review clock starts. So for cities, the review clock being 130 days, the county review clock being 150 days. But when the application is accepted as complete, then tribes would be given information about that and told where to go to look at the more detailed parts of the final application, and have the ability to provide information through the public process that then gets shared with the applicant and gets included in the record of the application. For landscape areas, notice to tribes of applications, again, that are reviewed through a public process. These are applications for development on rural lands, but there's not that that threshold of there being ground disturbance. The reason for that is these landscape areas are above ground, right? They're views or they're areas where certain plants grow that are important for collecting materials for basketry or first foods, or maybe they're areas on the ground that have been used for ceremonies over time, and so the ground disturbance is less relevant to those. I mean, they're important, but even projects without ground disturbance could impact one of these sites. These are areas, I should say, that they're not necessarily deemed to be significant yet. They are just areas of importance, and the idea is to spur a conversation. So more generally, for both archaeological sites and landscape areas, we hope to achieve better conversation and protections by noticing tribes of UGB amendments. And this is what I said, that when any response to notices come in, for whether it's about required under archaeological site parts of the rule or the landscape area parts of the rule, that the response to notice is shared with the applicant and included in the record of decision. And then what the rule says is that anything that comes out of these conversations will result in recommendations to be included in the local approval, not requirements. So they're recommendations to the applicant, not requirements. And the only time that we will get through this rule a requirement for an applicant, I guess, would be in two situations. One, we absolutely know, the local government absolutely knows there's an archaeological site that will be impacted, then the local government would need to require that the applicant get a permit from SHPO. And then somewhere down the line, as local governments add landscape areas of cultural significance to their own inventories and develop protections for those sites, then those local codes would have directives specific to those sites. But that would come down the line as a kind of result of the rule, but not from the rule itself. And next slide, please. So I just want to point out that some of the things that you'll see in this rule kind of exist already. So the Division 23 already requires that when there's a UGB amendment and factual information is entered in the record for that amendment, that Goal 5 is applied. So this rule emphasizes that, but it already exists in the rule for applicability of the division as a whole, which is the 0250 rule. And the standard Goal 5 process applies to landscape features. What we're describing here really could have happened in this rule, really could have happened all along under the Division 16 rule. So we're just kind of bringing it to the fore, adding a little bit more direction, I guess, for applying the Goal 5 process, but really that ability has been there since probably since Goal 5 was adopted, and certainly since Division 16 was adopted. And I've already talked about the optional government-to-government agreements that's in the rule and the need to shape the rule so that local governments have some more opportunity or ability to be consistent with the rule when they have local requirements that go beyond what the rule requires. And the effective date that we requested when this rule was submitted with the Secretary of State or filed the Secretary of State is January 1st, 2026. The intent there is to provide time for local governments to prepare for the rule and also provide time for state agencies and for the LCIS, Legislative Commission on Indian Services, to help get things prepared in time for the rule to be in effect, and develop guidance and support for local governments. And also give time for tribes to maybe get prepared for the large amount of notices that they would be receiving through this rule.
Amanda, can I make a point there too? I'm sorry, I was multitasking a little bit. Did you mention that year is imperative to develop support for local governments as well? You probably hit that first. But we know in terms of the program that we'd be wanting to provide sample notices, sample ordinances for procedure changes. And we would like to gather together a small working group of local government and tribal representatives to work on just some of those documents over the next few months, so that should the rule pass in December, we get going right away with sort of a meter of meetings to develop some of those supports. So Amanda, sorry if you mentioned that part of our needing to help get ready as well.
I mentioned not the intention to form an advisory group. So thanks for that. And I think that's the end, except for fielding questions, which I'm sure. Oh.
Good. Do we have our final closing beautiful slide to indicate
Wait a second.
brain
Here
that
we
we're
go. Oh,
I guess
sorry.
it's
Next,
on me.
next steps, right? So next steps on us, and so public comment period extends October 16th, and our hearing at LCDC on September 27th, and mention the rule effective date. And please visit our webpage to sign up for information and updates, and sign up for notices. And next slide, please. And this is for what we need to do as the state for which we just talked about, we need time to develop guidance, model procedures, coordination with LCIS and the tribes, and that is where LCIS will help work with the tribes to identify which for each of the tribes, which cities and counties they are interested in receiving notices from. And then again, for these next steps, what we're developing here, there will be information available on our rulemaking. Well, maybe on the rulemaking webpage, maybe at some point switched over to our Goal 5 web page, but one way or the other, information will be available through our website. And now we get to go to questions.
Thank you, Amanda. Thank you. I'll go ahead and take down the slideshow just to, because we're done with the slideshow. If folks would like to come on and ask your question, I see good questions from Carla and also a good point of clarification from our rulemaking advisory committee member Nicholas Tharn in the chat. Also, I do see that Alyssa, Dr. Bullion is with us from Legislative Commission on Indian Services. I just wanted to thank you, Alyssa, for being here. You know, if I was coordinated enough, I would send you a chat to say, would you like to be promoted? Come on and say hello. Before we do any of that, speaking of folks who are with us and might want to say hello, we do have Alexandra Ring with us. We have the outgoing and the incoming LOC representative here. Alexandra, would you like to say hello? I don't think we can hear you yet, ma'am. Sorry. I know. We do see you. We're making progress. Sure. No problem at all. No problem. You can just cut on in when you're back. So Carla, do you want to raise hand and come over and ask, or would you prefer to just be there in the chat? There's Alexandra. Okay. There's Alexandra. Hello. Yes, I can hear you. Yes.
Okay, still having some tech issues, clearly. This is why I joined late. We're still kind of figuring it out. I'm Alexandra Ring. I use she, her pronouns. I just joined a little over 2 weeks ago. The team here at LOC, I'll be a Renew Housing and Land Use Lobbyist. A lot of folks may know my predecessor, Ariel Nelson, who's now with City of Hillsborough. She's been a great resource to me as I get onboarded. So yeah, happy to be joining this work. Still very much getting up to speed, but things are starting to slot into place.
Great, awesome, Alexandra. Thank you. And there's only 19 statewide land use planning goals, so it's a finite.
No,
but then there is all that administrative rule and case law. So yes,
yeah.
thank you.
And I got the housing part of it in my brain. It's just the land use part of my job that I got. I got to about 10 goals so far.
That's great. That's great. It's a lifelong learning. We also have, for your reference, if you ever have a question and you would want to call someone who knows a lot about the statewide land use planning system, Mr. Ed Sullivan is on the call. He's a rulemaking advisory committee member. If you haven't had a chance to meet him, I would commend you to him. He's tremendous. So Carla has a question in the chat. Amanda, do you see it there? Thanks.
Yeah, I do, and I can respond to that.
Great.
Hi, Carla. So in the section 2 of the rule, where it talks about how this rule would interact with other rules, it says that a cultural area is significant for its culturally significant vista, which is identified as a significant scenic resource in a local comprehensive plan, shall be subject to the protection measures in the local code for that site and is not subject to this rule. So if a scenic area is already adopted in a plan, the protections apply as they apply. But for a new area, you know, there wouldn't be a huge difference, I think, in the review process for considering adding a Goal 5 site as a scenic site or as a landscape area of cultural significance, except that in this rule, it does say that the tribe will be recognized as a authority on the cultural significance or cultural importance of that site. And so, yeah, I think would be similar, but there's more weight given to a tribe's knowledge and experience with the site in the process to identify its significance, and then maybe the protection measures would differ if the protection is is specific to the tribal relationship to that scenic area versus the general public's relation to that scenic area. But I would just be musing as to what those differences might be.
While we bring Nick on for his question, could we take up Monica's question, which is related? Do you see that there, Amanda, regarding to 0160 natural areas?
Is it below? Oh, there's Monica. Okay. You know, I frankly have not had experience with Goal 5 natural areas. It's not a very active, it's not actively used, that part of Goal 5 and Division 23. So I don't have a good answer for that right now.
But we can work at it. Monica, thank you for the question. Nick is on now. Nick, you want to come on and say hello, ask your question?
Hi, yeah, Nicholas Starn with the City of Portland Planning Sustainability Bureau. I don't really have anything to add to the words I wrote. I just want to note that the Section 8 local sort of option that would take the place of the directly applicable portions of this rule are largely seem to be about consultation between jurisdictions and tribes, which is great. But I just wanted clarification that under that option, there's nothing in this rule that would prevent, through a process of consultation, the local jurisdiction to adopt a program that actually has required protections for resources that are identified through a land use process. Is that a correct assumption?
What do you mean resources identified through a land use process?
Oh, the local jurisdiction adopts a consultation program and an amendment to the zoning code that has
Yes.
geography that requires, looking at the applicant to show that there's no resource on site, or if there is a resource, there's some sort of protection measures that the local code describes. Like we have in Columbia South Shore or other jurisdictions might have for resources.
So a program, and so anything that's already in a local code applies. So acknowledged planning code will apply, and this rule won't affect that. For a new local program to protect, and can I just stick with archaeological sites as
that's what I mean mostly.
Yeah, so archaeological sites that are not of indigenous origin, the rule right now does not account for that well, because the rule, when it talks about the protections for archaeological sites, it says that the that strategies for avoiding impacts to the site will be recommended to the applicant. So the rule, we're recognizing that the rule needs to have somewhere in there a place where it says that while the rule does not require local governments to require certain things of an applicant for archaeological sites, a local government could. And in particular, and Nicholas, correct me if I'm wrong here, but the idea is that if a local government says, we know this area is very high probability of there being archaeology under the ground, and we want to require an applicant to do some surveying prior to development, then we think that this rule should allow the local government to have that requirement. And we do have to work out how, if it was adopted under Goal 5, how, Goal 5 has requirements for clear and objective standards and things like that. But we'll have to work that out, and I'll say right now that the rule does not have a clear provision to allow that additional local requirements that are chosen to be put on the books by a local government, and we will work to include that in the rule.
Right,
Okay,
because it's certainly not meant to prohibit that.
Okay, thank you.
Thank you, Nicholas. And then I wanted to just affirm quickly for Adam that Kelly Housley Glover with, I believe, Wasco County has been really instructive with us on the rulemaking advisory committee about the Columbia River Gorge system, and also Angie Brewer, who was the Gorge area planner for many years, is on staff with DLCD now and has been participating with our policy team to help alert us to how that's going. I know Amanda also has done some research there. So we are trying to learn from that. It is not one-to-one. But Adam, thank you for the flag. I do want to turn, Commissioner Thompson, I do want to turn to Mr. Vanzetta's comment. The Kirk has asked, how does owner consent factor into the designation of cultural areas? Amanda, if you could touch on that, please.
The advice that we've received from our attorney right now, who fortunately for us is also the attorney for state parks, who handles a lot of the historic protections through the National Register of Historic Places, and also works with local governments in developing local historic preservation programs. So right now, we do not believe that the owner consent provision in statute applies to cultural areas.
Kirk does have a follow-up question, which is, what are the objective criteria used to determine the significance of a cultural area? And that may be a little bit longer than we can go into proper depth here, Kirk, but thank you for the question. Amanda, did you want to touch on that one at all?
Well, one, if it's a cultural area that's important to the tribe, the rule says the tribe will be recognized as the I can't remember if it uses the word expert, but knowledge, the one holding the knowledge of what is of cultural significance. Nothing is said about cultural areas that might be important to otherwise a culturally identified group. But I will say that, remember, in Goal 5, there's 2 different steps, right? So you might find that a site is significant because all the information points to, yes, it's significant. But for landscape areas, the standard Goal 5 process will apply. So the next step is doing that EC analysis, right? So the analysis of the economic, social, environmental, and energy consequences of protecting or not protecting the site. And that is when, what comes out the other end of that will have to have considered the private property issues for that area. So it's not that this rule does not prescribe protections automatically to a significant site. That will be a public process that will have some protections applied to the site relative to what other uses would be allowed in that area.
Great. Just a few final notes. Oopsie, I just responded to the wrong group, but Nick had asked, I put it here, Nick had asked about what happens after October 16th. So DLCD staff will be reviewing each public comment. So please comment in writing. We'll be reading every word, reviewing it with our director, our legal counsel, et cetera, and making a recommendation to the commission for their December 4th and 5th meeting. This is a new practice for DLCD for about 3 years now, where public comment is accepted. There's a public hearing. The public hearing is September 27th. So please come testify. We'd love to see you. We'd love to see you. Yes, love to see you.
Absolutely.
Yes, please come. And it'll be in Salem, and you could Zoom in as well. There's sign up on our website, but I'll put it in the chat. Or maybe Kassara or Elliot, if you're able to drop that kind of sign up for public comment link in our chat on September 27th. And then we'll make a recommendation, a staff recommendation to the commission that'll go out 2 weeks before December 4th. So we'll just have that sort of 2 or 3 weeks to cohere a final set of recommendations. So we'll not be requiring periodic review. And another question earlier on that I think is pretty quick to take care of is the metro urban growth boundary expansions. And then I believe that we did add that the metro UGB would also be an opportunity to give notice to tribes.
I see 2 questions that I can address. So I'll do that one first.
Sure.
And Yes, Metro UGB expansions, so goal 5 applies to Metro UGB expansions, but the kind of sequence and timeline for steps might be a little bit different. But during the UGB expansion, if resources are identified in the UGB expansion process, then before urban development or urban zoning is applied, the goal 5 step should be completed at that point. And then there was a question about Columbia River Gorge, but Adam, you know, that's Adam's asking about whether what we're doing here is similar to the Columbia Gorge National Scenic Area. And I'm going to say, for a quick answer, no. We are aware and we know of those rules and or those requirements, and talked with, we actually have a county planner from Wasco County on our RAC, and we've had a former Multnomah County or Columbia Gorge area county planner on, who works for us and helps advise us. So the Columbia Gorge scenic area stuff really comes more directly out of other federal laws for protecting cultural areas, and we as a state are not bound by that, and so our approach is different. We also don't have the same support system that the federal entities have for arbitrating differences between what is a significant and what is not a significant site, and how they should be treated.
Thank you, everyone. It is 12:59. I want to thank Cassandra Taylor for joining us here as well. She's DLCD Senior Rules Coordinator, and we don't go anywhere without Cassandra guiding us through this process and many others. So thanks to Cassandra and Elliot for also putting some resources in the chat. I think LOC folks had to go. Brandon, thank you again for being here to and through the end. Really appreciate everyone being interested in these, being willing to learn along with us, and hopefully to progress towards a better Oregon for everyone. Any final comments?
No, it's fine.
Thank you, ma'am. Okay, thank you, everybody. We'll leave the chat open for a bit. So if you have a final question, you can put it there, or definitely email us, and we'll put this set of slides on our website as well with Elliot's help.